Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Now, we have of recent been on a kick where we spoke predominantly about Missouri medical marijuana laws, and we're going to go a little bit different from that today. Yesterday, Judge Peter Cahill in Hennepin County, Minnesota, threw out the third-degree murder charge against Derek Chauvin. He's the police officer accused of killing George Floyd. Now, the judge said that he tossed the third-degree murder charge because it applied only when an act is inherently dangerous to others. Okay? Only when an act is inherently dangerous to others. Think about that for a second, and we're gonna expand on that in a moment. Now, that doesn't mean the case is over. Chauvin is still charged with second-degree unintentional murder, as well as second-degree manslaughter. Now, look, every state's different in how they handle lesser included offenses. Is going to be a little bit different too. In the state of Missouri, if you're charged with, first-degree murder, and the state doesn't make that case, they may ask for an instruction on second degree or a lesser offense. Okay? So, for example, and we'll go with assault. That's a pretty easy one. Or burglary. A lesser included offense would be trespass. So the state can ask for that, and so can't the defense attorney. Usually defense attorneys don't want lesser included unless they think that your guy's probably going to go down, and lesser included is a better way to go. If you think the state has overreached with their top charge, you want to push them into an all or nothing. Now, every case is different. That's not a solid thing, but depending on the case, you may want to force the state into having to go put a jury in an all or nothing position where you think that you're going to be able to convince a jury that the state didn't make its burden. That's a ballsy call in a murder case where somebody died. A jury may have been willing to compromise on a lesser included. But you got to get into the facts individually. So let's look at the facts of the George Floyd case. Cahill said that the third-degree murder, which by the way is the one I thought applied, only applies when an act is inherently dangerous to others. Chauvin is accused of pressing his knee on Floyd's neck, and apparently didn't endanger anyone other than Floyd. I would argue that the judge is misreading that statute, possibly intentionally. But I don't practice in Minnesota, and I'm not going to take the time to go look up the Minnesota case law on this. But generally in Missouri, if we say that an act has to be inherently dangerous to others would mean anybody other than the person committing the act, which would include the victim, not somebody unrelated to the victim, which is just absolutely ridiculous. That is a stretch of logic that defies comprehension. Now, this is what I was getting at before. As a defense attorney, I want to take away your easy compromise. I don't want you to be able to say, yeah, okay, he's charged with a felony, but let's just all agree on this misdemeanor and go home. I don't want you to do that. Or I don't want you to agree on a lesser felony and send my guy to prison. I want you to have to say no to the top charge it's asked for because the state couldn't make that burden. In this case, the defense for Officer Chauvin got a little bit of help, taking away the charge that was clearly the best charge. I got to tell you, personally, I thought reaching for second degree was a reach at the outset. And, I even told a very good friend of mine who also happens to be my law partner, we discussed that, and I said, hey, here's the deal. They're going for second degree. They're not going to get it. He gets off. And he said, well, what about the lesser included? I'm like, lesser includeds will be dropped. They won't ask for lesser includeds. Because in this case, it's the prosecution that wants to make sure that the case can't be fucking made. Pardon my language. So, this is a story that came out in the Minneapolis Star Trib, I assume yesterday. It was reported by ABA Journal as well, very briefly. The essence of it is that they're stripping away some of the counts against Chauvin. They're reducing the evidentiary burden and the instruction burden on the jury when they get to that point. What that will mean ultimately is probably going to be that this guy gets off. Chauvin will most likely not face any real time or repercussions for killing George Floyd. So, that's my prediction. And then hell, maybe Minneapolis will burn. I don't know. Possibly. I hope not, because my family has some property in Minneapolis, and I would hate to see it damaged. The law is a very complicated thing, and in videos like this, I tried to distill it down and make it easy to understand. I want it to be clear, not confusing. But please make no mistake that a simplified explanation is not fully inculcating everything that goes into the process. As I tell clients, a criminal defense case is death by 1,000 paper cuts, where you're never going to have a Perry Mason moment. And I say that, and I remember I actually had a case with a Perry Mason moment. I had a witness on the stand who, under examination, admitted that she was the one who committed the crime. Which, that doesn't happen, usually. Usually it's attacking the state's case here, there, coming up with a plausible explanation for what happened or why your guy is not guilty. Why would the person make a false allegation against your client? Why would this mistake be made? You want to present an alternative theory to the jury. Sometimes all you have is, hey, they didn't prove it. And sometimes that's all you can do. Defended a rape case one time where, at the end of the day, we never said our client didn't do it. We just said that they couldn't prove it. And we won the case. But that was not an easy case. And, we took a couple risks in that case that could have turned out very, very bad for that client. But you had to. So when we talk about the attacks and we talk about, oh, well, you do this or something, another case might consider this, those don't necessarily transfer to every case. And especially in some of the interest communities I'm involved in, people tend to think of the law as black and white, and it's really more gray. Law is a living, breathing entity, like a dragon, that will burn and swallow you by mistake. And oops, it happens. And that's the reality of it. Is, yes, we talk about how the system works because somebody got clemency after 28 years in prison. Or we talk about how the system works because their conviction was overturned after 30 years in prison. Well, that person's not getting their life back. They're not getting their 30 years back. And there is no amount of money that can compensate the person for one prison rape. Okay? Let's not pretend that, oh, well, they got $6 million and they were in prison for 6 years. That's a good payoff. No, it isn't. They lost 6 years of their lives housed up in a cage with animals. And that's the way that people in prison are treated. Okay? You got guards that will treat them well. You have guards that will not. You have inmates that will treat their fellow inmates well. And you have inmates that will not. But let's remember that a lot of the people in prison are there because they can't function in a polite, organized society. They're there because they are violent and dangerous. And they're criminals. So when you put an innocent person in that environment, leave them there for years, and then take them out, you do not have a situation where that person can be made whole by handing them a check. You've stripped away a significant portion of their life. Now, regardless of what you may think of the facts of the case, I'm going to point to the Ryan Ferguson case in Missouri. Mr. Ferguson, Ryan Ferguson, whether you think he's guilty or not, he was released. And he got, I believe, a tidy check for that too. I could be wrong on that. But there's no amount of money that can compensate for the time in custody. It can't happen. Now, what happens next time he has any kind of interaction with law enforcement? According to the law enforcement point of view, he is a murderer that got lucky. How do you think they're going to handle the interaction with him? They're going to handle it tougher. They're going to handle it stricter, where you might have gotten a written warning for your speed, he's getting a ticket. Where you might have gotten a ticket, he's going to jail. Where you might have been left off, let go of the ticket, he's going to be on the side of the road while they search his car. And eventually, something else will happen. Something will happen. Yeah, that's a cynical view of the world, man, but defense attorneys are cynics. And we are oh so hopeful cynics. It's a real dichotomy frankly, I think we're all psychotic. But you can't restore the time somebody spent in prison because the system screwed up. And what I'm getting at is you cannot depend upon your layperson research to keep yourself out of jail or prison if you are charged with a crime. You need a lawyer. There's a very, very high profile drug case going on in central Missouri right now. It involves two people who had asked for a public defender, were denied. Ultimately, that was appealed, and one of them now is on a public defender waiting list. They're a married couple. Discovery is going, the case is still going. They filed motions on their own behalf, which should not have happened. They really hurt themselves with the own motions that they filed. And it's the kind of thing that will result in their being convicted. So why do I point to that? And I'm pointing to it without naming it because I don't want to overly draw attention. I think they're probably great people, but they're making tragic errors. And when you look at it, they're trying to do legal research themselves, but they don't understand what they're doing. And that's because they don't have the benefit of 3 years of law school to teach you how to do it and how to evaluate it. And then the years of practice it takes to determine what is important and what isn't. So that's a fundamental issue that you have to pay attention to. Things like this case in Minnesota, George Floyd's murder and the case against Mr. Chauvin, that's a classic example of why you need to be aware of what is happening and how. Because if you're not paying attention, you're going to sit back and go, hey, he got off. I'm telling you right now, based on the way the case is laid out, this guy's going to get off. It is extremely unlikely they're going to be able to prove second-degree unintentional murder based on what I know of the evidence and their law in Minnesota. Now, I'm not a Minnesota lawyer. I could be wrong. No. For the sake of everyone involved, I kind of hope I am, because if history is any marker, if this guy gets off in Minnesota on the death of George Floyd, there's going to be a lot of damage and a lot of violence, and a lot of people are going to get hurt. Probably better that Chauvin gets convicted and then wins his appeal, just for the public good. Not for Chauvin, but for the rest of society. So, yeah, it sucks, man. I'm going to ask you to hit like, subscribe. We're going to talk more about how the law works in future episodes as well. And we're going to talk about some specific issues facing Missourians and our laws. One thing we have to look at is search and seizure law, specifically in a motor vehicle. Is the smell of marijuana still grounds for a search of your vehicle? I don't think smell of marijuana alone is. I've said that for, more than a year. I think that that's changed, and we will talk about that in a future episode. Please hit like, subscribe, smash the alert bell so you know when we post our next video, and you have a good day. Thank you.